The topic of today's discussion, Clay, is amending the Constitution. And the debate has been whether amending the Constitution is a good or bad thing. How do the Founding Fathers feel about this?
Well, first of all, they were emphatic that the Constitution needs to be amendable. You know, under the Articles of Confederation, our first national Constitution, an amendment required unanimous consent of the 13 states. Well, it's almost impossible to get 13 very different states to agree on anything. And so it became a fossil. It couldn't be made current with changing circumstances. And so when the 55 Founding Fathers met in Philadelphia in the summer of 1787, they completed their work by saying there will be a mechanism whereby this basic social compact can be changed to stay current.
Well, doesn't this make, because it's so difficult to amend the Constitution, doesn't this make, again, the Supreme Court more powerful?
It does. The Founding Fathers, if they could see things in retrospect, if they could look at it the way we're looking at it, and it's been over 200 years, and there have only been 27 amendments to the Constitution, and two things about that, Sam. Number one, the first 10 were instantaneous, the Bill of Rights, so they almost have to be seen as a constitutional afterthought, that they're in a sense a part of the Constitution. So since then, there have only been 17, and if you go through them, about half of them are procedural. What happens if the president dies in office? If the president is disabled, how do we get the vice president into his seat and so on? These are interesting things, but they're effectively procedural questions. But the substantive ones, voting rights for African Americans, voting rights for women, voting for 18-year-olds, these more important civil rights and voting rights amendments have been very few. And so the Founding Fathers would probably say they set the bar a little too high, that it needs to be a little easier to amend. I should just tell you that there's a double mechanism in the Constitution. You can amend the Constitution if 2/3 of both houses of Congress propose an amendment, but even that, after these two supermajorities, the amendment has to be passed by 3/4 of the states. That's 38 states. That's a tough test. Or 2/3 of the states can demand a constitutional convention. That's never happened. But if they did, then presumably another group of Founding Fathers and mothers would appear and revise the Constitution.
Now, there have been somewhere in the order of about 5,000 amendments proposed
To Congress. You know, there are thousands and thousands have been proposed by people saying, well, we need an amendment for this, but 5,000 have actually been introduced into the Congress of the United States since 1789. Of those 5,000, only 33 have gotten through Congress. And of the 33 that have made it through Congress, 27 have actually passed. So only 6 amendments out of those 5,000 have gotten through Congress and then not gone on to be ratified by 3/4 of the states.
Tell us about some of your favorites.
Well, of the ones that have not gotten through, let me just go through those 6. There was one on the size of the Congress. That was the first one.
What were they trying to do?
Just to limit the number to set the number, of representatives, because otherwise it could spin way out of control. It's of no consequence. The second one forbade titles of nobility, and it said that any American who took a title of nobility from a European court would be disbarred from American citizenship. Never passed. The third, maybe the darkest of them all, the Corwin Amendment of 1861, would have protected slavery. It would have said the national government cannot adjust fundamental institutions within its states. It was an attempt to stave off the Civil War. Didn't pass. The fourth, Child Labor Protection Act in 1924, never ratified. Everyone knows the Equal Rights Amendment from 1972, equal rights for women, never ratified.
And that was an amazingly long battle at a time in the United States history when, if it was ever going to occur, you would have thought it would occur, starting in the 60s.
Right. Well, it didn't happen, which is surprising. You would have thought that it would have been ratified. It came, as you know, very close several times and then pulled back. But a lot of people think that, in a sense, women's rights are covered under the 14th Amendment to the Constitution, the Equal Protection Clauses and so on. So honest people could disagree about whether that was a wise amendment, but whatever the case, it didn't pass. And then the final one, full voting rights for the people of the District of Columbia, has never passed. So those 6 out of the thousands and thousands that are routinely offered up. One allowing prayer in schools, put God back in the Constitution, define marriages between a man and a woman. You could name hundreds, literally thousands, abolish the Electoral College, clarify the question of eminent domain, a balanced budget amendment. Every year, hundreds of constitutional amendments are proposed. None of them get out of Congress. If they get out of Congress, it's almost impossible for them to pass.
Now, the one there with for the folks who live in Washington, D.C., to not have representation, it amazes me that that is still in effect today.
It is odd, Sam. I don't understand it. The people of D.C. are allowed, by way of constitutional amendment, to cast votes for the president. They are counted in the Electoral College. But they do not have other full voting rights as American citizens. So you would expect that this would be sort of a no-brainer, but it has proved to be problematic. For one thing, the District of Columbia was in the Constitution set out as a special federal reserve that's not part of any state, and so it has a kind of difficult and ambiguous legal basis in American life. But secondly, it's really just the problem of amendment. If 38 states have to ratify any amendment, that gives enormous power to a minority in this country to hold it up. The people of Montana may say, well, we're just against this because we hate government. And the people of Utah may say, we're against this because it will alter the power of the Electoral College. All you have to do is get that little rump of people, of naysayers on any question, and an amendment won't pass. So probably, if the Founding Fathers saw this, they would try to lower the bar a little, maybe make it 2/3 in the House and the Senate, and maybe pull it down to 2/3 of the states. But it's clear that it will be very difficult for future amendments to occur.
Here's a few questions to think about and discuss. Question 1. Do you think we should change the mechanism for amending the Constitution? Question 2. If you were in charge of the universe, what amendments to the Constitution would you propose? Question 3. Do you think we've had too many or too few amendments to the Constitution? Question 4. Do you favor a balanced budget amendment? Question 5. Do you favor an amendment declaring that marriage is a relationship between one man and one woman?
Let's talk about Jefferson and the Constitutional Convention and what he wanted to see.
And keep in mind that Jefferson was not at the Constitutional Convention. He was in France. He and John Adams, two of the most brilliant of the Founding Fathers, happened to be absent during this critical period. Jefferson watched with interest from afar, as did John Adams, and in a sense, they were the two people you would really have wanted to have been there, but they weren't there. Jefferson was concerned about the dynamism of a republic, of a society, and he argued that you need to be able to change the Constitution quite frequently so that it keeps pace with the progress of humanity. His concern was, why would we allow the dead hand of the past to control the future? And if he could see our situation, 27 amendments in over 200 years, he'd be appalled. Here's what he said. It's a really interesting thing he said in 1816. Some men look on constitutions with a kind of sanctimonious reverence and deem them, like the Ark of the Covenant, too sacred to be touched. They ascribe to the men of the preceding age a wisdom more than human and assume what they did to be beyond amendment. He said, I am not for frequent and untried changes in laws and constitutions, but I know this too, that our basic institutions must keep pace with the progress of the human mind. He said, we may as well require a man to wear the coat that fitted him as a child as to require our civilized citizens to live under the regimen of their barbarous ancestors.
And who was against this?
Everybody. Because the genius of it, Sam, is that you want a constitution that's very hard to amend. You don't want there to have been 7,000 amendments since 1789. You don't want it to be frivolous. So you need to get the bar high so that there has to be a real supermajority of the American people to make basic changes, prayer in school, outlawing abortion, abolishing the Electoral College, homosexuality, balanced budget. These are fundamentals. And you want to make sure there is almost a unanimous consent by the people of the United States to make these changes. But that made more sense in an age of elites when basically a handful of prominent white men controlled the country. Now that we have mass democracy, getting near unanimous consent on these questions is almost impossible. So Jefferson wanted the following. You create a constitution, you have strict construction, you adhere to it just as literally as you can, but you amend it whenever you need to. And he went even farther. In a letter to James Madison from Paris, he said, and we should tear up the Constitution on principle every 19 or so years. So he envisioned a series of literally construed, often amended constitutions. That's not what we got. We got this sort of living constitution that was set in stone in 1787 and has barely ever been amended. And we then have to take that instrument and see if it applies to situations that were never contemplated by the founding fathers.
So almost stretched.
You have to stretch it. So, what did James Madison know about heart transplants? What did James Madison know about patent law in the age of the internet? What did James Madison know about pharmaceuticals in a global economy? And so, if you have this Constitution written in the 3-mile-per-hour world, which hasn't been amended to make sense of pornography and moon exploration and so on, then that makes somebody, that happens to be judges, have to say, what can we take out of this Constitution that somehow applies to that unprecedented situation? Gives judges power.
Well, what does this mean then when you hear people talking about wanting Supreme Court justices as constructionists? They want to go back to the original.
We've put them in an impossible situation because we don't have a constitution that addresses our concerns. We have a constitution that addresses eternal concerns, but we don't have one that addresses the issues of today. For example, in Jefferson's time, the Second Amendment protected ownership of guns. Well, a high-tech weapon in Jefferson's time was a musket, single shot. Well, how much damage can you do with a single-shot rifle? Now, some knucklehead with a 9mm handgun can shoot 50 people before he can be wrestled to the ground. The technology has moved the debate, but we're still stuck with that Second Amendment that we passed in the age of muskets. Surveillance. In the age of Thomas Jefferson, a search required someone to knock on your door. You had to open the door. They came in and looked for whatever they were searching for. Today, electronic surveillance, satellite communications, infrared, the tracing of our electronic transactions. If you're in Chicago or New York and you go on the freeways, your car sets off a little electronic detonation and they can trace every step you've made. Those situations, those technologies have altered the debate, but we're still stuck with these very generalized Newtonian principles from the 18th century. So the answer, it makes the judges extremely powerful because somebody has to decide, and they're the only ones who can.
What about lobbyists? We know that lobbyists are legion in Washington, D.C. today, thousands upon thousands of them. What was it like back then?
There were lobbyists. Wealthy people always lobby. If John Adams were here, he's a much more cynical man than Thomas Jefferson, but he would say the wealth of the world will always get more votes than it deserves. And so even in Jefferson's time, the Hamiltonians, as we like to call them, had better access to senators, to presidents, to the Supreme Court than common farmers living in Maryland or Virginia. This has always been the case. And now we know that lobbyists play a really important part in the creation of legislation. They know, they're experts. A senator from Minnesota isn't necessarily an expert on cloning. So the lobbyists are important. The question is, how can you distill their points of view, which are never objective, into law that's meant to be fair and objective? But that's something that no amendment could ever get at, the power of money in American life.
Let's talk about the voting age being lowered to 18. This started out in 1942, but it didn't get ratified until 1971. It is amazing that people were going to wars and yet did not have the ability to vote.
You're speaking like someone who was a child of the 60s. The amendments have come in clusters. The first 10 amendments came right after the Constitution was written. They're called the Anti-Federalist Amendments, and the 11th and 12th are usually put in that class. Then we had the Civil War, this enormous national cataclysm, and following it there were 3 amendments, the 13th, 14th, and 15th, freeing slaves, the Equal Protection Clause, and voting rights for African Americans. Then there's a long quiet period. Then you have the Progressive Era, as represented by William Jennings Bryan and Fighting Bob La Follette and Theodore Roosevelt and Woodrow Wilson, and you get voting for women, direct election of senators, and income tax. You get the progressive agenda. Then there's a long quiet period, and in the 60s, some other things came to the fore, and one of them, I mean, the Equal Rights Amendment didn't pass, but the one that did was voting rights for 18-year-olds, and the rallying cry was, in an age of the draft, how dare you take our sons to war if they can't vote for the very government that makes those decisions? It makes sense, doesn't it?
It sure does.
But it was hard to pass, and it would be harder to pass today.
Really? Why would you say that?
Because it's gotten, in an age of CNN and 24/7, 365 media, where everything is a crisis, where everything inevitably gets blown out of proportion, because there's a fixation on the instantaneous and there's no contextualization. So that kind of a media situation enables people to sort of respond, not thoughtfully, but spasmodically to what's passing. And so if you proposed an amendment today, let's say that marriage is a sacrament between one man and one woman, just try to get that passed. I mean, there would be so much outcry from so many different directions, from philosophers, from constitutionalists, from the homosexual community, from the Christian community, in every direction, some for, some against, that it would become a nightmare. There isn't enough cover of thoughtfulness and deliberation any longer in our system to enable there to be a serious deliberation about these kinds of questions. It's a crisis. We have a crisis of a culture which is sort of paralyzed by distraction. We're so distracted that we can't really sit down and think, what would a good constitution look like in the 21st century?
It's interesting because the issue you really raise is that the amount of information available is so overwhelming in every direction that it counts against good governance.
Absolutely, and the amount of noise. It's not just information. There is an overstimulation, there's an overload of information, but there's also noise. Pick any subject, same-sex marriage, or gun control, or prayer in school, and do a Google search. And suddenly, instantaneously, hundreds, even thousands of websites spring up, and because of the wizardry of our information age, they all look like they're well-funded and professional and thoughtful. That's not necessarily the case. And so it used to be that we took our public information through very narrow channels, and we had authoritative figures like Walter Cronkite, and we also had an educational system that trained young people in civics so they knew a little bit about this history. Today it just comes as sort of perpendicular information and stimulation from all over, and the citizen body is frankly as much interested in Kobe Bryant or Lindsay Lohan as it is in gun control or same-sex marriage. And so there's a kind of a cheapening of constitutional discourse in an age of media.
Here are some more discussion questions. Question 6. Should Washington, D.C. receive statehood? Question 7. Make a list of the fundamental amendments and another list of the merely procedural amendments. Question 8. Which amendments do you think are the most important in the history of America? Question 9. Why do so many amendments get proposed and so few get passed? Question 10. Who should decide what an amendment to the Constitution means? For example, recently, politicians have argued that children of immigrants are not protected under the provisions of the 14th Amendment.
Let's talk about the concept of functional amendment of the Constitution. What does that mean?
Well, first of all, let me say that Madison, the father of the Constitution, got it exactly right. He said we need a Constitution because we are equally against that extreme facility which would render the Constitution too mutable, change too often, and that extreme difficulty which might perpetuate its discovered faults. So you need the geniuses figuring where to set the bar. I think it was set too high. It might not have been set too high for the 19th century but it was certainly set too high for the age of media that we've been talking about in the age of overstimulation. Donald Lutz of the University of Houston has said, and I quote, "The U.S. Constitution is the most difficult to amend of any constitution currently existing in the world today." Strong words. So then what? If you have a dynamic society where all these things come up that you have to face, and yet your Constitution can't be adjusted, what do you do? Well, there's something called functional amendment during the New Deal. Franklin Roosevelt did a lot of things that weren't constitutional, but we allowed him to do them because we knew they needed to be done. And so he just sort of worked around the barriers. Or take treaties. Treaties are extremely important to the United States. The president engages in a treaty, say with Great Britain, but the Senate has to ratify it, 2/3. That's proved to be an extremely difficult constitutional barrier. So instead of amending the Constitution to say, well, maybe the Senate doesn't have so much control, the president has entered into what are called executive agreements with Iran, with Iraq, with Vietnam, with Britain. These don't require a 2/3 majority in the Senate. These can be done by a simple majority in the House and the Senate. So the presidents have worked around. Most famous case is the Lend-Lease Law, which occurred in World War II, where the United States helped Britain stave off Nazism. That wasn't a treaty. Franklin Roosevelt did it by executive agreement. Or today, presidents offer executive orders on every possible subject. Instead of going to Congress to get something done where it's just too cumbersome for them, they just sign an executive order and they do it unilaterally, and unless some court or some entity stops them, they get away with it. So we have effectively run around some of these concerns to find other mechanisms to get things done. Very dangerous from a Jeffersonian point of view. It works, it's efficient, but it's not playing by the rules.
What about signing statements where a bill is passed, the president signs it, but he can, and it can be any president, and make notes to say, I'm not going to follow this law?
It's not in the Constitution. The Constitution is just a vague set of general pronouncements, and they didn't give the president this explicit authority. The president has a right not to spend money appropriated by Congress. If Congress says we're going to spend $100 million on arts, the president can impound that money, and the Congress has no choice but to let him get away with it unless they impeach him. This is a separation of powers question. A signing statement occurs when a president gets money and say we're going to spend $400 million on a baseball stadium somewhere, and he says, well, I'm not going to do that. I'm going to sign the bill, but I'm going to effectively have a line item veto by telling you how I intend to interpret that bill or to spend the money. It's not constitutional, Sam, but it's allowed because there's nothing to check it. And that's the issue. We have the Constitution, and it's in plain English. But there's a whole sort of constitutional world vaguely around it, like an aura or a cloud. And that isn't documented, but it's extremely important to the way we do business. Jefferson would say, you want to get all those things down on paper so that we have rules of engagement, rules of separation of powers, rules of checks and balances. And if you don't, it allows all these sort of gaping loopholes through the Constitution, which a powerful president will use, which a powerful judiciary will corrupt, which a powerful legislature will distort. That's not a protection for the American people, however efficient it may be.
Now, doesn't the difficulty of amending the Constitution lead to demagoguery?
It certainly does. So take flag burning, and people take this very seriously. But a politician will say, you know what, we need a constitutional amendment to ban flag burning. Well, that's just a throwaway statement because it's not going to happen. I've already talked about how high that bar is, and so it would be almost impossible to amend the Constitution on same-sex marriage, on flag burning, on prayer in schools. And so politicians, knowing this, they have the right to lifers come to them and say, you must do something about abortion. And then the politician says, yes, I'm going to introduce an amendment and we'll get this thing taken care of. And then this poor group goes off and works tirelessly to make this thing happen, but the politician knows and probably says that night over cocktails, that'll quiet them down. This will never happen because it is virtually impossible to amend the Constitution. So all these good faith efforts occur by well-meaning Americans who believe strongly in these issues, and their work is almost bound to be frustrated by this mechanism we have for amendment.
Let's briefly talk about congressional raises.
You know, that's so funny because in the original Bill of Rights, the amendments that Madison drew up in 1789, there was a provision to prevent Congress from voting itself raises. It never passed. It would have been the First Amendment rather than the one that we all cherish. It finally was passed in a different form in 1992, and today that was the last amendment passed, 1992, and it says that Congress can vote raises for itself, but they can't come into effect until the next Congress convenes. In other words, you can't vote yourself a raise while you're in office. You have to go back to the people, and presumably if you voted a raise, they can decide whether to retire you at that point. That one's been around for more than 200 years, and it finally passed. And it's kind of a silly one. I mean, the American people get all upset over this, but the amount of money we spend on our elected officials is minuscule compared to the amount we spend on a single day of war or on health care or Social Security and so on. But this matters to people. It's part of their last sense that they control their own government.